Earlier this week, the Federal Trade Commission announced something that I think is the single most beneficial piece of legislation that I've ever seen regarding veterinarians, and that is they are banning non-compete clauses. In this video, I'm going to discuss what non-competes are, why they negatively impact veterinarians so much, how I've been impacted by them, what this new ruling says and does, and why I think it's a good thing that these non-competes are going extinct. But please guys, before I do that, smash that like and subscribe button, help spread awareness of this topic, grow the channel, grow the video. And let's begin. So what are non-compete clauses? Federal Trade Commission defines a non-compete clause as, quote, a contractual term between an employer and a worker that blocks the worker from working for a competing employer or starting a competing business, typically within a certain geographic area and period of time after the worker's employment ends. In other words, an employee's contract states that if they leave their job for any reason, fired, quit, or otherwise, they can't work in the same field for a certain amount of time and within a certain geographical radius of their current job once they leave. The Federal Trade Commission reports that 18% of employees in the U.S. are working under a non-compete clause in their contract. But I can tell you, though, that these non-competes are extremely common in veterinary medicine. I've been a vet since 2009, and I've worked in about 6 24/7 ER specialty clinics throughout my career, and every place I've ever worked, every company makes you sign a non-compete clause in order to work there. The reason non-competes exist in veterinary medicine is because of what I would consider an irrational fear on the part of practice owners. That fear being that an employee can set up shop across the street from your practice and take all of your business. But guess what? Yeah, they could. It's called a free market system. And in my opinion, every employee has the right to start their business anywhere they choose, whenever they want to, if they want to. Employers oftentimes seem to want to have the right to put a stake in the ground and declare some sort of invisible border within which is the only area that you, the vet, can practice in. But you know, this isn't the gold rush. Now, back in January 2023, the FTC announced that they are proposing this rule against non-competes because, as they put it, non-competes do the following. Number one, they restrict workers from better employment opportunities. Number two, they prevent workers from leaving jobs. That decreases the competition for workers and thus that lowers worker wages. And number three, they prevent new businesses from forming, they stifle entrepreneurship, and they prevent novel innovation which would otherwise occur when workers are able to broadly share their ideas. Now, to illustrate this point further and how non-competes can negatively impact a veterinarian's job and ability to move up in their career, let me give you a personal example. Back in 2016, I started my first job as a neurologist. I was in Chicago working with a company that will just leave nameless for now. I was fresh out of my residency and I definitely had a learning curve to get through. I signed a contract with this company knowing that it had some serious flaws, but my thinking was I had a learning curve to go through and my colleagues seemed great, which they were, so I went ahead and signed it. One of those flaws was a pretty severe non-compete clause. The terms of the non-compete were as follows. Upon termination of my contract, i.e. quitting or being fired, I could not work within a 25-mile air radius of the hospital for 2 years afterwards. Again, I didn't think much of this at the time, but fast forward to 2020, COVID hits, I'm on the top of my learning curve, I'm doing pretty well in my career, and I, like so many vets post-COVID, go looking for a better opportunity. Being a boarded neurologist, I was fortunate enough to find opportunities pretty quick. In fact, one such opportunity was right outside of the city. This was a great opportunity with huge upside and a significant bump in salary that was way, way beyond what my current employer was willing and able to give me. I checked to see how far this clinic was away, and I'm not kidding. It was 24.8 air miles from my current hospital. Now, if you've ever been to Chicago, this is like a 90-minute commute through 12 different major neighborhoods. Not exactly the same market. After some back and forth with various contract attorneys and my prospective new job, I went back to my current employer with a proposal to see if I could have my potential new employer buy down the radius, essentially paying my current employer to reduce the air mile radius by 0.2 miles so that I could take this opportunity. Again, we're talking about a new job 24.8 miles away in one of the most densely populated areas in the entire country. How is this even a problem? What negative impact could I possibly have working 24.8 miles away instead of 25? Well, apparently it's a big problem because I was told that if I left to go work at this new place, my current practice ownership would, quote,
pursue litigation against me to the fullest extent possible.
Exact words. Now, in case you were wondering, that translates to our multi-million-dollar company will sue you back to the Stone Age for doing this and have fun fighting it by yourself. I'll never forget those words from management. I've been producing over $1 million in gross receipts for this company for years, and then suddenly I'm being threatened by a lawsuit if I go work 24.8 miles away instead of 25. Like an extra 0.2 miles somehow makes an enormous difference on them. Also, as a side note, if you draw a circle with a 25-mile air radius around the hospital, basically around Chicago, like half the circle is in Lake Michigan, which I find hilarious. Now, you might be watching this thinking, well, this can't possibly hold up at court, right? I see this opinion a lot from veterinarians in various places, especially Facebook groups like Not One More Vet and Debt Free Vets. But that's easy to say and a lot less easy to pay to fight for. Attorney fees are required to fight such a lawsuit easily top $50,000 to $100,000 from the quotes from attorneys and the experiences I've gathered in talking to people who actually went through this process. Oftentimes, if you go to battle against a non-compete, you'll end up settling for some amount that is usually in the healthy 5 figures or sometimes 6-figure range. You may have one, but that's not the point. The goal from the companies are simply to discourage you from doing this because they know how hard this can be on an individual veterinarian. It's basically you versus an entire gigantic company. So the conclusion here was, if I wanted to change jobs, I have to essentially move outside of the city. And this is why non-competes are so detrimental to all workers, not just veterinarians. You have to basically pack up and move anytime you change a job. How is that fair for us again? As it relates to me in this scenario, and I'm sure many vets, I was basically stuck. I mean, don't get me wrong, I was making a good living at the time, but I was stuck in the sense that I was missing an opportunity working for a job that paid substantially more than a job 24.8 miles away. Extrapolate this out across the country and you can see how many veterinarians are unable to freely move from job to take advantage of better opportunities. The net effect here is to stifle wage growth and discourage job mobility in the veterinary profession. This is not good for vets. I would also argue that non-competes also contribute substantially to negative well-being and mental health issues that plague the veterinary industry. You do not have to search very far to find stories of young or new grad vets being stuck in what I like to officially call nightmare job scenarios. These are job scenarios where during the interview process, certain things like mentorship, production bonuses, time off, adequate support staff, scheduling guarantees, etc. are promised, but after a few months, none of that pans out and the job is totally different than you expected. And not in a good way. Veterinarians, especially new grads who don't have the experience to sniff this out, oftentimes find themselves given no mentorship whatsoever. Many people report being ignored or bullied and having to work way more than they were told they have to. You'd want to leave a nightmare scenario, right? Well, if you've got a non-compete clause in your contract, which you very probably do if you're a vet, that's going to be a lot harder to do. You'll either have to move out of the city that you're in, or you'll have to pay a humongous sum of money that you probably don't have yet because you're a young vet. If you want to read more about what I'm talking about, this article right here provides a really good anecdote to the situation. Fortunately, the Federal Trade Commission is apparently banning this practice, which, as I said, I fully support. The ruling goes into effect 120 days after its publication in the Federal Register, and I have no idea what that means, but hopefully that means a few months from now. Now, there are some details in the ruling that I think are important for vets, especially since so many of us are currently working under a non-compete clause in our contract. The FTC ruling states that existing non-competes can remain in force for employees who are what are called senior executives. A senior executive is defined as an employee who earns more than $151,000 a year and is in a policy-making position. For veterinarians, this translates mainly, I think, to like medical directors, so I apologize to all the medical directors out there. Now, I do want to be clear, my company that I talked about was and is by no means the only company that would do this, nor is this private information. You can go on the VIRMP website, that's the vet version of Internship and Residency Match, and you can pull up other companies' non-compete clauses as well. If you're a vet student or a vet, you can also ask colleagues, and I'm sure within 1 to 2 degrees of separation, you can find answers to questions you have on non-competes by company. All right, guys, let's all take a moment and say a collective good riddance to non-competes. Finally, after 15 years upon graduating from vet school, they are now gone. Hopefully they're gone permanently. I fully support getting rid of non-competes altogether. I think non-competes are the second worst thing in veterinarian contracts behind residency repayment clauses, which I made a video about a few months ago. Thanks for watching. I hope you enjoyed that. Please leave a comment below. If you're a vet or if you're a person who has experienced problems with non-competes, let me know. I always like hearing experiences from other people who face similar challenges. Don't forget to hit that like and subscribe button, and I'll see you on the next video. Take it easy.